Donald Trump's legal battles just collided in a way no one expected. Judge Tanya Chutkan, already presiding over his January 6th case, has just fast-tracked a lawsuit that could expose the inner workings of his administration's handling of Jeffrey Epstein. The Department of Justice tried to stall, using bureaucratic silence to bury the truth, but that silence has now backfired spectacularly. We are looking at the potential exposure of communications that were meant to stay hidden forever. Based on the court order and the specific filing from Democracy Forward, we analyze the devastating implications. What is happening here is a perfect storm of legal pressure, statutory obligation, and judicial impatience, all converging on one of the most sensitive and politically radioactive subjects imaginable. The core of this story begins with a lawsuit filed by a watchdog group called Democracy Forward. They, like many Americans, had profound questions about the handling of the Jeffrey Epstein case during the Trump administration. They wanted to see the documents. They wanted to see the emails, the memos, the communications within the Department of Justice and the FBI that would explain the decisions that were made, or perhaps more importantly, the decisions that were not made. So they filed a Freedom of Information Act request, or a FOIA request. This is a tool, enshrined in law, that is supposed to give the American public a window into their own government. But as anyone who has ever dealt with the federal bureaucracy knows, that window is often painted black. The Department of Justice under the current administration, dealing with a request about the prior administration, did what bureaucracies do best: nothing. They delayed. They stalled. They effectively ignored the request for so long that it triggered a legal concept known as a constructive denial. Think of it like this. If you ask someone a direct question and they simply stare at the wall and refuse to answer, their silence becomes an answer in itself. In the legal world, that silence gave Democracy Forward the standing to sue. They took the DOJ to court, arguing that the public has an urgent and exceptional need to know what happened inside the highest levels of law enforcement concerning a case that has shaken public trust to its core. The mainstream media, by and large, reported this as a minor procedural step. What they missed was the strategic genius of the lawsuit. It wasn't a broad, fishing expedition. It was a surgical strike, aimed at a very specific set of potential records. The lawsuit demanded to see communications related to the Epstein matter that involved specific people and specific topics. They wanted to see any and all materials related to the briefings given to and the meetings held by a woman named Pam Bondi. They also demanded to see any directives given to the staff who were reviewing the voluminous Epstein files. And here is the kill shot. They specifically requested any documents that contain mentions of Donald Trump himself, within the context of the DOJ's Epstein review. This was not about relitigating Epstein's crimes. This was about investigating the investigators. It was a direct challenge to the integrity of the Trump-era Department of Justice, and it posed a fundamental question. Was the DOJ's primary goal to pursue justice for Epstein's victims, or was it to manage and contain a political problem for the President of the United States? The constructive denial from the DOJ was, in essence, a dare. And the lawsuit was the answer. Now, to understand the gravity of this, you have to understand the hidden architecture of power and information in Washington. The Freedom of Information Act was passed in 1967. For those of us who remember a time before the Internet, a time when government secrecy was the default setting, FOIA was supposed to be a revolutionary tool for transparency. It operates on a simple, powerful premise. The records of the government belong to the people. But over the decades, the executive branch, under both Democrats and Republicans, has built a massive fortress of exceptions, delays, and bureaucratic obstacles to neuter the law's intent. They will claim national security exemptions. They will claim deliberative process privilege. They will claim, most often, that they are simply too overwhelmed with requests to possibly respond in a timely manner. They put your request in a queue that is thousands deep, and tell you that you might get an answer in 5, maybe 10 years. By then, of course, the information is ancient history. The guilty parties have retired, and the public has moved on. It is the art of the slow walk, a form of soft obstruction that is perfectly legal and maddeningly effective. The timeline here is absolutely critical to grasping the potential for a cover-up. Let's go back. In the mid-2000s, Jeffrey Epstein was given what is now infamously known as a sweetheart deal by federal prosecutors in Florida, a deal overseen by then United States Attorney Alex Acosta. This deal allowed a serial predator of young girls to escape meaningful justice. Fast forward to the Trump administration. In a surprising turn, Donald Trump appoints that very same Alex Acosta as his Secretary of Labor. Then, in July 2019, the political calculus shifted. The Southern District of New York, then operating with a degree of independence, arrested Epstein on federal sex trafficking charges. The world was stunned. It seemed like accountability was finally at hand. Acosta was forced to resign from his cabinet post due to the renewed scrutiny of his role in the Florida deal. The administration was now in full-blown crisis management mode. Then came the most shocking twist of all. On August 10, 2019, Jeffrey Epstein was found dead in his cell at a federal correctional center in Manhattan. The official cause was suicide, but the circumstances were so suspicious, the security lapses so profound, that it ignited a firestorm of conspiracy theories that burns to this day. The key figure in the case, the man who held the secrets of countless powerful people, was silenced forever. For the Trump administration, this was both a blessing and a curse. On one hand, a politically damaging trial was averted. On the other, the cloud of suspicion and the stench of conspiracy would now hang over everything. This is the moment, in the late summer and fall of 2019, that is the focus of this lawsuit. What was happening inside the Department of Justice in the weeks and months after Epstein's death? What was the strategy? Who was calling the shots? This brings us to Pam Bondi. Her entrance into this story is, by most accounts, the single most suspicious element of the entire affair. Bondi had been the Attorney General of Florida. During her tenure, her office was criticized for its inaction on complaints related to Epstein. She was seen by many victims' advocates as part of the system that had failed them. Yet, in November 2019, just a few months after Epstein's death, the Trump White House hired her as a special advisor. Her portfolio, according to public statements, was to work on impeachment defense, but it was widely reported at the time that she was also tasked with overseeing matters related to the Epstein case within the administration. Can you imagine the optics? The former top law enforcement officer of the state where Epstein got his sweetheart deal, a person with her own political baggage related to the case, is brought into the White House to handle the fallout. It's like hiring the fox to design the new security system for the henhouse. It begs the question, was she hired for her legal expertise or for her institutional knowledge of where the bodies were buried in Florida? The backroom mechanics of power are rarely about a single, dramatic moment of conspiracy. They are about a series of nudges, quiet conversations, and carefully worded memos that create a desired outcome without leaving obvious fingerprints. The motive for the Trump administration to control the Epstein narrative was overwhelming. First, there was the Alex Acosta connection, a direct link between the president's cabinet and the original failure of justice. Second, there were Trump's own documented, albeit decades old, social encounters with Epstein. While he was never accused of any wrongdoing in the case, the visual association was a political nightmare. In the world of high-stakes politics, perception is reality, and the perception was toxic. The logical move for any administration, especially one as obsessed with managing optics as Trump's, would be to put the entire matter into a lead-lined box and bury it at the bottom of the sea. This is where the alleged slow walk comes in. The working theory behind the lawsuit is that the administration's strategy was not to solve the Epstein case, but to contain it. This would involve several steps. First, you centralize control. You bring in a trusted political loyalist like Bondi to be the gatekeeper of information. Second, you instruct the career officials within the DOJ to proceed with extreme caution. You create new layers of review for any document release. You tell them that everything needs to be vetted for political sensitivities. Third, you use the creaking machinery of the bureaucracy itself as your weapon. You respond to FOIA requests with boilerplate letters. You claim the records are part of an ongoing investigation, even if that investigation is dormant and you run out the clock. The goal is simple: survive the news cycle. Survive until the next election. Hope that the public's notoriously short attention span moves on to the next shiny object. For a time, it seemed to be working. So why now? What changed? Two things. First, Congress, in a rare moment of bipartisan agreement, passed the Epstein Transparency Act. This law created a new, clear statutory obligation for the government to organize and release records related to the case. It signaled that the political will in Washington had shifted. The desire for answers now outweighed the desire for partisan protection. This act gave any future legal challenges much sharper teeth. But the second, and most immediate, catalyst was the judge assigned to the Democracy Forward lawsuit, Judge Tanya Chutkan. When her name was drawn, those in the know understood that the game had changed. The DOJ's strategy of delay and obfuscation was about to run into a brick wall. Judge Chutkan is not a household name for most Americans, but within the legal and political circles of Washington, she has a formidable reputation. Appointed by Barack Obama, she has presided over some of the most sensitive cases in recent memory, most notably hundreds of cases related to the January 6th Capitol riot. In those cases, she has developed a reputation for being a no-nonsense jurist who does not suffer fools gladly. She has consistently handed down tough sentences and has shown very little patience for defendants' attempts to downplay the severity of their actions. More importantly, in cases involving executive privilege and government secrecy, she has consistently ruled in favor of transparency and congressional oversight. She famously wrote in a ruling against Donald Trump's attempt to block the release of White House records to the January 6th committee, "Presidents are not kings, and the plaintiff is not president." This is not a judge who is easily intimidated by political power or impressed by the excuses of government lawyers. This brings us to the crisis moment for the Trump world, Judge Chutkan's order. She didn't just rule that the case could proceed. She granted the plaintiff's motion for expedited processing. This is a rare and powerful move in the world of FOIA litigation. A judge will only grant it if they are convinced of two things: that there is an exceptional public interest in the information, and that the plaintiffs would be irreparably harmed by the normal, glacial pace of the process. In her decision, Judge Chutkan essentially agreed with Democracy Forward on all counts. She affirmed that the public's need to understand what its own government was doing in the Epstein case was not just a matter of curiosity, but a matter of urgent national importance. She recognized that justice delayed is justice denied, and that transparency delayed is transparency denied. The order itself is the defining moment. Imagine the scene. In a quiet federal courthouse in Washington, D.C., a judge reviews the arguments. On one side, you have the Department of Justice lawyers making their standard arguments about backlogs and procedural fairness. On the other, you have the lawyers for a watchdog group, arguing that the integrity of the entire justice system is at stake. Judge Chutkan signs the order. With that signature, the Democracy Forward FOIA request, which was likely languishing at the bottom of a pile of thousands, is immediately moved to the very front of the line. The DOJ's favorite excuse, that they are just too busy, is vaporized. They are now on the clock, under the direct supervision of a federal judge who is known for her impatience with delay tactics. The wall of secrecy has been breached. The civic impact of this cannot be overstated. What this means is that we, the American people, are now one step closer to finding out if the immense power of the United States Department of Justice was used not to bring a monster and his enablers to justice, but to protect the political fortunes of a sitting president. It means we might finally see the memos from Pam Bondi. We might see the email chains discussing how to handle media inquiries. We might see the draft talking points that were circulated within the White House. And most critically, we might see documents that show a pattern of deliberate interference, a conscious effort to bury inconvenient facts. This is not about partisan politics. It's about the fundamental principle of equal justice under the law. Does that principle apply to everyone? Or do the powerful get to play by a different set of rules, using the government itself as their shield? Let's take a closer look at the characters in this drama, because their motivations and histories are key to understanding the stakes. First, you have Judge Chutkan, who has become the unwitting driver of this entire process. From the perspective of this narrative, she is not a political actor, but an institutional one. Her role is to apply the law as it is written. Her power comes from her impartiality. The fact that she is also overseeing the criminal case against Donald Trump for his actions surrounding January 6th adds a layer of spectacular irony. The very judge who holds his future in her hands in one courtroom is, in another, forcing the secrets of his administration into the light. It's a case of political jujitsu, where the system he once commanded is now being used to scrutinize his own actions. Then there is the central figure of Pam Bondi. Her career arc is a case study in political loyalty and its rewards. As Florida's Attorney General, she was a staunch conservative ally of then-Governor Rick Scott. Her office's handling of the Epstein case was just one of several controversies she faced. She also came under fire for dropping a potential investigation into Trump University after receiving a campaign donation from a Trump-affiliated foundation. Her subsequent hiring by the Trump White House was seen by critics as a reward for her loyalty. The documents forced into release by Judge Chutkan's order could either vindicate her, showing she was engaged in a legitimate and professional review, or they could expose her as a political fixer tasked with a cover-up. The request for her directives to staff is particularly telling. Were those directives aimed at uncovering the truth or at containing the damage? Her communications, her calendar, her meeting notes, they are now all potential exhibits in the court of public opinion. Finally, there is the institutional character, the Trump Department of Justice itself. It's important to remember that the DOJ is not a monolith. It is composed of tens of thousands of career prosecutors, agents, and staff, many of whom are dedicated public servants. But at the top, the leadership is composed of political appointees, the Attorney General, the Deputy Attorney General, the heads of the various divisions. These are the people who set the priorities and the tone. During the Trump years, under Attorneys General Jeff Sessions and later William Barr, the department was under constant and immense political pressure from the White House. The question that these documents might answer is how that pressure manifested in the day-to-day handling of a case as explosive as Epstein's. Did a politically appointed official tell a career prosecutor to stand down? Was a line of inquiry shut down because it led too close to a friend of the president? These are the questions that keep U.S. attorneys up at night, and they are precisely what this lawsuit aims to uncover. Now we must consider the risk and contingency. What if, after all this, the documents are released and they show nothing? What if they are utterly benign, revealing only a professional, by-the-book review process? If that happens, then this story becomes a footnote, and the Trump administration can claim vindication. But the very nature of the government's response so far suggests that is an unlikely outcome. The prolonged delay, the constructive denial, the fight in court, these are not the actions of an institution with nothing to hide. If the documents show what the plaintiffs allege, if there is even one email from a senior official saying something to the effect of, "We need to be careful how we handle this," the boss is mentioned in some of these files, then the entire dynamic shifts. It becomes a story of obstruction. It becomes a story of a cover-up. And it becomes a political firestorm for Donald Trump as he campaigns for the presidency, forcing him to relitigate one of the sleaziest episodes in recent American history. This entire episode needs to be framed within a much broader national context. This is about more than just one president or one criminal case. It is a profound test of our system of checks and balances in the 21st century. For decades, the power of the executive branch has been growing, while the oversight powers of Congress and the transparency tools available to the public have been eroding. We have seen a paradigm shift where administrations increasingly view the machinery of government not as a public trust, but as a political weapon to be wielded against their enemies and a shield to be used to protect their friends. This lawsuit, and Judge Chutkan's order, represents a powerful countercurrent. It is a reassertion of the principle that no one is above the law and no administration is above scrutiny. The lesson here is a crucial one for our time. It demonstrates that the deep state, so often invoked as a shadowy cabal of rogue agents, is often something far more mundane and yet more corrosive. It is the reflexive, institutional instinct of the powerful to protect themselves. It is the quiet conversation in the deputy director's office about managing the optics. It is the decision to classify a document as deliberative process to keep it from a FOIA request. It is the culture of secrecy that pervades any large bureaucracy, amplified by the intense pressures of partisan politics. What this case shows is that the most effective antidote to that culture is not more politics, but the methodical and relentless application of the law. It is the work of determined watchdog groups who refuse to take no for an answer, and the courage of independent judges who refuse to bow to political pressure. It is a slow, grinding process, but as we are seeing now, it can produce results. Let's elevate this conflict to what it truly represents. This is a symbolic clash between two competing visions of American government. On one side, you have the vision of an executive branch with broad, almost unchecked power, where the president and his appointees act as the sole arbiters of the national interest, and where transparency is a courtesy to be granted, not a right to be demanded. In this vision, loyalty to the president is the highest virtue, and institutional processes are mere obstacles to be overcome. On the other side, you have the vision of a government of laws, not of men. A vision where the institutions of justice are independent, where transparency is the default, and where accountability is not just a political slogan but a legal requirement. This court order is a victory, however temporary, for that second vision. For those of us who have lived through multiple administrations, who remember the promises of transparency from both parties that were inevitably broken once they took power, this moment feels different. Your generation understands this better than most. You have seen the cycle of secrecy and scandal repeat itself time and again. You saw it with Watergate, with Iran-Contra, with the justifications for the Iraq War. There is a deep and understandable cynicism in the American public about whether we can ever truly know what our government is doing in our name. This case, focused on a subject of such visceral public disgust as Jeffrey Epstein, has the potential to cut through that cynicism. It is a reminder that while the arc of the moral universe is long, sometimes, with enough pressure, it can be bent toward justice and toward truth. So what does this all mean moving forward? The Department of Justice, under the command of a federal judge, must now begin producing documents. This will not be an overnight process. We can expect a protracted battle over redactions. Government lawyers will fight tooth and nail to black out names, paragraphs, and entire pages, citing privacy concerns, ongoing investigations, and national security. They will lose some of those battles, and they will win others. But the process has been irrevocably set in motion. The dam has a crack in it, and the water is starting to seep through. The trickle of information will soon become a stream, and then, perhaps, a flood. This legal process will unfold against the backdrop of a presidential election. Every document that is released, every revelation that emerges, will be instantly weaponized by political opponents. It guarantees that the ghost of Jeffrey Epstein will continue to haunt Donald Trump throughout his campaign. It will force him and his surrogates to answer questions they desperately want to avoid. It creates a new front in the legal wars that have defined his public life. But this one is different. This is not about his business dealings or his personal conduct. This is about his conduct as President of the United States. It is about whether he used the awesome power of his office to interfere in a criminal investigation of unprecedented public interest. In the end, this story is about two fundamental values that are in constant tension in a free society: the need for the government to operate effectively and the right of the people to hold that government accountable. This case forces us to confront the reality that those in power will almost always choose secrecy over transparency if given the choice. Their motives may be corrupt, or they may simply be cautious, but the result is the same: a government that operates in the shadows, shielded from the view of the citizens it is meant to serve. Judge Chutkan's order is a powerful assertion that the choice is not theirs to make. The law, in this case, demands a reckoning. What this means, in the simplest terms, is that the narrative is no longer under the control of those who want the secrets kept. The master stroke of this legal challenge was to take the power out of the hands of political appointees and place it into the hands of a federal judge. The unraveling has begun. We do not yet know what these documents will ultimately reveal. They may show a conspiracy, or they may show mere incompetence. They may implicate the highest levels of the administration, or they may only embarrass a few mid-level officials. But we are now, finally, going to get a look behind the curtain. And that, in itself, is a victory for the American people. The final, lingering question is not just what is in those documents, but what it will tell us about the fundamental integrity of the institutions we are supposed to trust. What else are they hiding?